Hello, everyone. This is Bob Quinn, the CEO of the New Hampshire Association of Realtors. And today, I'm fortunate to have with me Chris Norwood. Chris is the chair of our 2024 Public Policy Committee. Good morning, Chris. How are you doing?
Thanks for having me, Bob.
Good, great to have you. So this was a pretty busy year in the state legislature, and we're going to talk about a few bills that passed and the governor now has signed. And one area that was of particular interest, apparently, to the legislature was on notification to property buyers prior to execution of a purchase and sale contract. Many of you are already familiar with Section 12 of a purchase and sale, requirements of radon, lead, and arsenic. But the legislature's added a couple others, haven't they?
Yeah, and it's probably been about a decade or so since we last revised this section. So if you're following at home, it's RSA 477. These are notifications prior to the transfer of real property in the state of New Hampshire. So the first one we should talk about is PFAS contamination. And while I can't pronounce actually what PFAS stands for, we all know it is a very, very dangerous substance. These are the so-called forever chemicals. And while there's parts of the state that they're more heavily dominant in, it's really ubiquitous throughout the state. And so this is a notification that the realtors did support. We thought our buyer clients should be aware and draw their attention to how they can find out more information if they are concerned about PFAS contamination in their groundwater. So that was the first part of, or one of the bills. Some of the other bills, Bob, flood is another one. And now flood, a lot of folks might know that flood insurance is administered at a national level, and it's something that we as realtors have often gone to DC. But here on the local level, the first iteration of this bill wasn't something that we were terribly comfortable with. It got into some disclosures about the prior owner's insurance or lack thereof for flood, and we didn't think that it was quite hitting the mark. So the solution was to put this notification for flood into Section 477. So now our seller clients will have to inform the buyer about these potential notifications for flood insurance. The last one is a little bit more quirky. It's really specific to commercial property. And so the concern here is if you have a seller of commercial property that has a restaurant, specific to restaurants, where the capacity of the septic is a determinant of the density of tables, that there needs to be a disclosure in the purchase and sales agreement that notifies the buyer where they can turn to research the density of the septic system. At least that's as I understand it.
I think that's you got it.
Okay, good.
So,
thank you, Bob.
So the PFAS bill is, for those playing along at home, is House Bill 398. The flood and requirement notification is House Bill 1320. And the food establishment septic bill is House Bill 1144. All three bills do not go into effect until January 1st of 2025. So NHAR will be making updates to its standards forms, its purchase and sales, and those will be available prior to January 1st of next year. So, and also I want to mention that the governor is in the process of signing a lot of bills. Once he has completed signing, probably later this summer, early fall, NHR will be providing membership with a list of all of those bills. So stay tuned for that. Chris? The housing was a big topic within the legislature. And a couple of bills came forward and have been passed, which are designed to alleviate the housing inventory crunch we're experiencing right now. So one of those bills is House Bill 1400, having to do with parking, right, Chris?
Yeah, so a lot of the town restraints on density, sometimes it's a straight up density, how many units, sometimes it's a height thing, but oftentimes it's parking. If you only have so much land, particularly in an infill urban environment in our state, the local municipality could dictate you need X number of parking spaces per unit. Well, 1400 would make it so that towns have restrictions on the amount of parking they can require on an individual unit for a new development. There are a lot of details on the number of units and density, but broadly speaking, it limits to say no more than 1.5 spaces per unit, which is lower than others. I will say, just from personal experience, this is not something that was kind of created out of thin air. There were a lot of municipalities in our state that were already doing this progressively. I think Dover is probably the best example of someone who was leading by example, and it has helped fuel some additional housing needs in that community.
Yeah. It's funny because the House of Representatives passed a bill that was mandating you're only allowed to have one parking space per unit. The Senate passed one that said 2. So lo and behold, they came together and compromised at a number in between at 1.5. So.
Compromise. It's such a dirty word
in
politics sometimes.
Another bill that passed is House Bill 1359. And 1359 has to do with the definition of what it is, who is an abutter when there's an appeal from a local land use board decision.
Yeah, and for those who may or may not have been on the receiving end of an appeal over the years, you may have heard that there is a New Hampshire Supreme Court case that used to be the gold standard as to who the definition of an abutter was. Well, what we've done, and we're not going to read this text, you have to go look it up or have your civil engineer or your lawyer look it up, but it's a very concrete definition of who an abutter is, and it really limits the definition of an abutter to somebody who physically is abutting the land parcel that you're talking about, or across the stream, across the street. And so what we're hopeful that this does is that this may limit the number of frivolous abutter appeals if somebody is, let's say, across town and they're not directly an abutter impacted by a land use board's decision about a property.
Yeah, and that was a bill that both the realtors as well as the municipal association got together and agreed upon and helped pass, which doesn't happen.
Yeah, I mean,
that often.
I agree, Bob, because I think from a municipal perspective, they were probably looking at this and saying, yeah, we don't want to be on the receiving end of a lot of these appeals either. It takes up capital, it takes up time and resources, and so they wanted to make sure that only truly aggrieved parties to a planning board or a zoning board decision had the right to appeal, and it wasn't something that was, again, frivolous across town.
Another bill that I know we were involved with and you testified on was House Bill 1361, which was an attempt by the legislature to sort of encourage municipalities to permit manufactured housing.
Yeah, and again, I think that this is another one of those bills that we're going to trip up if we try and read it verbatim. Best to have, if you're interested in manufactured housing development or expansion, this is the bill that will really catch your eye. And what it does is it allows for existing manufactured housing parks. It gives them some ability to expand their existing footprint. It also clarifies municipalities' need to allow for, I think it's reasonable and realistic opportunities for manufactured housing in their community. So a much more of a clarity bill. Manufactured housing as it existed in the state for years and years and years. So this is just a clarity bill that is kind of long overdue.
Yep. And finally, House Bill 1065 has to do with what structures need to be sprinkled and which ones don't, correct? And this one makes it a little easier for conversion into residential properties.
Yeah, and so if you read current statute prior to this new bill, I believe the language is a municipality cannot mandate sprinkler systems in one or two families, basically a single family or a duplex. This bill would expand that to say 1, 2, 3, or 4 families is exempted. So again, in Concord, we use a lot of double negatives, so sorry for this, but essentially, if you are planning on converting from any use to a multifamily use that is 4 units or under, the municipality cannot mandate a sprinkler system in that space.
Great. Well, it was, as we mentioned, it was a busy legislative year in 2024, and we look forward to a similarly busy year, hopefully, in 2025 as they look to expand housing opportunities in the state of New Hampshire. Chris, thank you for joining us today.
Thank you.
Great.
For having me. Yeah, I can't remember a busier legislative session, and this is my 5th year being the chair.
Yeah, a lot of bills debated. We were involved in dozens of them. And we're here to talk about a couple of them that have passed and have been signed by the governor and will be going into law later this year. The first one we want to talk about is Senate Bill 480. And this one specifically has to do with an issue relative to real estate licensing and what is oftentimes referred to as post-licensing, right?
Yeah, and so our members may remember that a number of years ago it was passed that the first 2 years that you obtain your real estate license, you had specific courses that you needed to take. There had been some confusion surrounding the merger of the Real Estate Commission and OPLC. So what this bill would do, it would put back on the books and clarify those courses. And so for those of you who are curious or, inviting a non-licensee to get their license, the 4 courses that new licensees will have to take are purchase and sales agreement, ethics, disclosures, and agency. And so that had been on the books, but again, it kind of had fallen by the wayside over the past couple of years.
Yep. And so this year, the legislature did pass a bill which is going to bring 480, the post-licensing, back again. And we're talking with the Office of Professional Licensing to try to determine how that's going to be implemented in 2025. But folks should be at least aware of it, especially if you're getting a new license.
Yep.
Another bill that we were heavily involved in fact, introduced at the legislature was Senate Bill 502, which many folks may be surprised to learn that we were surprised, we didn't know this as well, that if you do ask somebody you're trying to identify who may be calling you or communicating with you, you ask them to send you their driver's license electronically, that is in fact prohibited by state law, right, Chris?
Yeah, and so what was happening is you would get a circumstance like this. You'd get a phone call that would say, hey, I'm Johnny Jones. My grandmother just passed away, and they left me some land in their will. Bob, would you list it? And Bob, of course, being an opportunist realtor, would say, yeah, let me dig up some information and so forth. Well, what was happening is Johnny Jones was calling Bob under false pretenses, and really it was land fraud or title deed fraud, whatever you want to call it. In order to protect ourselves as realtors, we wanted to take a photocopy of Bob's license or have him send not Bob, Johnny Jones. Bob, I'm not saying you did this. It wasn't you. This fraudster, Johnny Jones. But as Bob said, it was illegal. The only institutions in our state that are allowed to take photocopies of license are financial institutions or oddly enough, pawn shops were allowed to do it. So now realtors are in the same status of pawn shops. I'm happy to notify everyone.
Yeah. It was an interesting little twist is New Hampshire, you were prohibited from accepting a New Hampshire driver's license. But if someone was from Massachusetts or Delaware, you actually could accept that license. It was only specific to New Hampshire driver's licenses.
Yeah, we really felt it was protecting not only the licensee but also buyer clients and the underlying person who owns the land. I think that the legislature and the Department of Safety saw the similar path, and so this bill 502 is now law. And so I would urge you to read up on the law before you go asking everyone for their license, but it is something that's important, and unfortunately this type of fraud was taking place.
Great.